to the parties as we prosecute the case, as we talk to more witnesses and talk to, in some cases, more co-defendants and cooperating witnesses. That's been the case in the prosecution of Jermarcus Johnson. As we told Your Honor in chambers, I think the court is aware, the state now understands the exact participation of Mr. Johnson in the conspiracy with regard to the murder and cover-up of the murder of Adolph Thornton, Jr., known as Dolph in the community. Mr. Johnson had no, Mr. Johnson, Jermarcus Johnson, had no involvement in the homicide before the murder. He had no involvement in the homicide during the murder. His involvement was after the fact. About a week after the murder of Adolph Thornton, his brother, Justin Johnson, who in fact was one of the shooters and one of the killers of Adolph Thornton Jr., came to him and gave him certain property. A car, not the car used in the murder, but nevertheless the car that Mr. Justin Johnson had possession of, and a cell phone. The cell phone is of particular importance because it was Justin Johnson's cell phone that he had during the murder and that he had used for some time before. This Mr. Johnson agreed to take possession of the car, and he agreed to take possession of the cell phone. His taking possession of the cell phone and the car aided in Mr. Justin Johnson's continued evasion from authorities and his continued cover-up of the conspiracy. This Mr. Johnson also used the telephone. He used the telephone by his brother Justin would call the telephone, and he'd place the telephone up to another telephone, and they would, in essence, trick Justin Johnson's federal probation officer into believing that Justin Johnson still had his cell phone and was still in Memphis, Tennessee, when in fact he had fled after murdering Adolph Thornton and was not in our community. He also did the same thing where he placed Justin Johnson's cell phone up to another cell phone, and he facilitated a conversation, again, this is over a week after the homicide, between his brother Justin Johnson and the other shooter of Adolph Thornton, Cornelius Smith. Mr. Johnson preserved the telephone and turned it over to authorities. He spoke with the state, and he's described the content of that conversation and the content of some text messages between Cornelius Smith and Justin Johnson that included Mr. Justin Johnson trying to get money to Cornelius Smith after the killing. Mr. Jermarcus Johnson has given truthful statements to the state with regard to all those acts. Those are 3 acts of an accessory after the fact that did aid in the cover-up and this conspiracy. For those reasons, now that we understand those to be the facts of his involvement, now that he's given a truthful statement with regard to these things, he has also identified a picture of his brother Justin Johnson wearing the outfit of one of the shooters of Dolph just directly before the homicide. Now that he's been 100% cooperative and truthful, we're asking Your Honor to accept a guilty plea and recommendation in the case. There's a criminal information that is before Your Honor. It has 3 counts. It's I-2300019. It alleges 3 counts of accessory after the fact for those 3 acts that I just described to the court: taking possession of the car, the cell phone, and then using the cell phone to facilitate those communications. Even though Mr. Johnson is a range 1 offender, he has no criminal history. He's agreeing by this guilty plea, which is open to the court, that he should be sentenced as a range 2 offender. These are E felonies. Range 2 for an E felony carries 2 to 4 years incarceration. He's pleading guilty to all 3 counts of the information to those 3 E felonies, 2 to 4 years incarceration. He's also agreeing that when Your Honor sentences him, that all 3 of those sentences should be consecutive to each other. So Mr. Johnson is in essence pleading guilty to the court, open to the court, to a sentence that can range between 6 and 12 years when Your Honor sentences Mr. Johnson.
Sir.
The parties are not asking Your Honor to sentence Mr. Johnson presently we're asking Your Honor to delay the matter, to reset it for sentencing.
Yes, sir.
There are conditions of release pending sentencing that are outlined in a separate sentencing memorandum, which is filed with this guilty plea.
Yes, sir.
And at a later date, the state will request that Your Honor sentence Mr. Johnson. I've stated the facts at the start of the plea, so I ask for counsel to stipulate to the facts. I'll just very, very briefly, basically 2 or 3 yes or no questions asked of Your Honor, Mr. Johnson, during the guilty plea.
Yes, sir.
I'll ask Your Honor to accept the plea after that.
Mr. Corman.
And Judge, I believe that would be the evidence the state would present in the case going to trial. We do stipulate there's a factual basis, and we're going to ask the court to accept our negotiated settlement.
Mr. Corman, Mr. Hagerman, thank you. Mr. Johnson, Jermarcus Johnson, come around, please, sir. Mr. Johnson, come up here where Deputy Chambers is. And once you get to the seal of Shelby County, put your left hand on the Bible and raise your right hand to be sworn, sir. Do you solemnly swear or affirm the testimony you've given this cause to be the truth, the whole truth, and nothing but the truth to help you God? Thank you, sir. Mr. Hannah, Mr. Johnson, have a seat here on the witness stand, please, sir. Counsel, approach, please. Yes, sir. Deputy Chambers. Ms. Hagerman, please. Need your signature and my signature on the document, Mr. Hagerman. Thank you, sir. Mr. Jermarcus Johnson, good morning, sir. Mr. Johnson, what's your real name, sir?
Jermarcus Johnson.
You need to speak up a little bit louder. The court reporter here has to write down everything that's said. Of course, I need to speak up a little bit louder. You can take the mask down if you want to. Yes, sir.
Jermarcus Johnson.
Mr. Johnson, what school did you go to, sir?
To Wooddale High School.
How far did you get in school?
12th grade.
Did you finish the 12th grade?
No, sir.
Did you ever get a GED, sir?
No, sir.
Can you read and write okay, Mr. Johnson?
Yes, sir.
Mr. Johnson, answer those questions because the law requires you to answer, okay?
Okay.
A couple of things, Mr. Johnson. You were charged by way of an indictment 2204769 and charged with conspiracy to commit first-degree murder.
Yes, sir.
That Class A felony carried anywhere from 15 to 60 years in prison. You're pleading guilty on a superseding information, I-2300019, and charged with 3 counts of accessory after the fact. That's an E-felony, carries up to 6 years in prison. You understand that, sir?
Yes, sir.
Mr. Johnson, you have a right to have this case, this charge submitted to the grand jury. When you enter a guilty plea on this information, you're waiving. You've given up your rights to have this case of accessory after the fact submitted to the grand jury. That case comes to court quicker when you plead on an information. The state will make you the best offer they will ever make on an information, but you're giving up, you're waiving your rights to have this case on an accessory submitted and reviewed by the grand jury. Do you understand that, sir?
Yes, sir.
Is that what you want to do, sir?
Yes, sir.
For the record, I will find that Mr. Corman and this court have advised Mr. Johnson has the right to have this charge of accessory after the fact reviewed by a grand jury. If the grand jury found probable cause, they would indict him. If they did not find probable cause, they would no deal this charge. They'll find that Mr. Johnson has made that decision intelligently and knowingly. Mr. Johnson, I'm going to show you a document for the record. This is a petition for waiver of trial by jury and request for acceptance of the plea of guilty. On that bottom right-hand corner where it reads defendant, did you sign that, sir?
Yes, sir.
Mr. Johnson, all of your rights are above your signature. Those are your state and federal constitutional rights. Did your attorney, Mr. Corman, go over those rights with you and explain them to you, sir?
Yes, sir.
Do you understand the rights that you're waiving and giving up today, sir?
Yes, sir.
Mr. Jermarcus Johnson, you heard Mr. Paul Hagerman, the prosecutor, recent statements in court a few minutes ago. When you enter this guilty plea, when you enter this change of plea today, you're telling the court that if you had a trial on your case, the state of Tennessee would bring witnesses to court. Those witnesses would testify under oath. They would say things that are similar, that are consistent with what the prosecutor just read. You're telling the court, Mr. Johnson, that if a jury believed those witnesses, that jury would have enough reason to find you guilty of accessory after the fact. You understand that?
Yes, sir.
You have an absolute right to have a trial on your case if you wanted one. You have a right to say, Judge Crawford, I'm not guilty of anything, and I want a trial. Judge, I am demanding a trial. And had this case been tried, you would have a right to confront and cross-examine those witnesses against you. Say you have to bring those folks to court. You can look at them in person. They would sit right there on that chair on the witness stand where you're seated. Your lawyer, Mr. Corman, would question those folks to see whether or not they are telling the truth. If a jury did not believe those witnesses, or if that jury thought they were lying or mistaken, that jury would find you not guilty, and I would dismiss your case. Do you understand that, sir?
Yes, sir.
Had you gone to trial in this case, Mr. Johnson, you would also have the right to present proof. You could put on witnesses if you wanted to. You could present evidence. You don't have to do anything at a trial ever. If you wanted to, and only if you wanted to, you can take that witness stand and you can testify. You can tell the jury what happened. You can tell the jury your side of the story. If you chose to remain silent and not say a single word, I would tell that jury they cannot hold it against you for any reason at all. Do you understand that, sir?
Yes, sir.
Mr. Johnson, had you gone to trial in this case, if you had any witnesses that could help you, your attorney, Mr. Corman, would send them a subpoena and have them come to court and testify for you. If your witnesses didn't show up, well, they just flat out refused to come to court, I would have those folks arrested by the sheriff. I would make your witnesses come in. I would make them testify. And if I had to, Mr. Johnson, I would put them in jail until your case was tried. Do you understand that, sir?
Yes, sir.
Had you gone to trial and had a jury found you guilty of anything, you can appeal any conviction the jury gave you. You can appeal any punishment that I gave you. The Court of Criminal Appeals would grant you a new trial or even dismiss your case if that court found mistakes had been made in your trial. If you could not afford an attorney, I would appoint someone for you free of charge to handle your appeal. Do you understand that, sir?
Yes, sir.
Mr. Jermarcus Johnson, when you enter this change of plea, when you enter this guilty plea, you waive, you give up all those rights. You ask this court to find you guilty without a trial. And Mr. Johnson, both sides are recommending that I do not sentence you today, that a delayed execution of these judgments is set this case for a sentencing hearing. And at that sentencing hearing, Mr. Johnson, you'll be sentenced somewhere between 6 and 12 years in prison. Now, is that the agreement you have to state in Tennessee, sir?
Yes, sir.
Mr. Johnson, you've been sworn to tell the truth. Do you understand that, sir?
Yes, sir.
Everything that you say under oath has to be true. If you do not tell the truth, the state could indict you for perjury. That carries up to 12 years in prison. Do you understand that, sir?
Yes, sir.
Before I continue with this guilty plea colloquy, Mr. Johnson, Mr. Hagerman has asked the court's permission to ask you some questions. You waive your right to remain silent when you enter this guilty plea. So listen to the questions that Mr. Hagerman asked of you, sir.
Yes, sir.
Make sure you answer those questions truthfully. You understand that?
Yes, sir.
If Mr. Hagerman and Ms. Mond said, Judge Coffey, we don't believe Mr. Jermarcus Johnson has been truthful, they're going to ask the court to vacate this guilty plea. They will strike this guilty plea, and your case will go back to the same status as was before this information was found. You understand that, sir?
Yes, sir.
Any questions, sir?
No, sir.
Mr. Hagerman, you may proceed, sir.
Mr. Johnson, we have talked before, is that correct?
Yes, sir.
And when we talked, you told me about meeting with your half-brother, Justin. He's your half-brother, is that right?
Yes, sir.
You told me about meeting with your half-brother, Justin, about a week or so after the murder of Adolph Ford Jr., is that right?
Yes, sir.
You told me at that time that he gave you a car, is that right?
Yes, sir.
You told me at that time he also gave you his cellular telephone, is that correct?
Correct.
You told me that, or did you tell me that afterwards you used that cellular telephone at his request?
Yes, sir.
Did you describe to me a scenario in which you would place one phone up to another while Justin was on another phone for the benefit of his parole or probation officer?
He was called to get somebody's number, and I would put it to my phone
down on the bed, and I put somebody else on right there and let them talk to each other.
And you told me about the times that you did that, is that correct? And you also described times not just with the probation or parole officer, but also with an individual known to you as C. Is that correct?
Yes, sir.
And you now know that individual to be Cornelius Smith, is that
Yes,
right? And you described to me, and you turned this phone over, and in it were text messages with this individual C, is that correct?
Yes, sir.
And some of these text messages, some of what you witnessed was conversation with regard to money that Justin would be getting to C, is that correct?
He asked for money, yes, sir.
That's for money,
Yes, sir.
is that correct?
Yeah. He was asking for money for somebody else, from somebody else.
Okay, and that somebody else was referred to as Unc, is that correct?
Yes, sir.
Okay, so this would be money that C asked for from Justin that Justin was going to get from Unc.
Yes, sir.
Is that correct? You described all that to me.
Yes, sir.
You've also looked at some photographs that included one of your half-brother in a particular outfit, and you identified Justin Johnson, your half-brother, in the photograph.
Yes, sir.
Do you understand that one day you may be called to testify in trial on this matter?
Yes, sir.
Will you tell the truth that time?
Yes, sir.
Have you told the truth with me?
Yes, sir.
No further questions, Judge.
Thank you, Mr. Hagerman. Mr. Cormier, you have any questions of Jermarcus Johnson?
No question. Thank you, Judge.
Mr. Jermarcus Johnson, the felonies that you pled guilty to, accessory after the fact is a Class E felony. It carries anywhere technically from 1 day to 6 years in prison. You understand that, sir?
Yes, sir.
You have agreed under what's called a hybrid guilty plea, State versus Mailer and Hicks, State versus Hicks, in which you're agreeing to plead outside of your range. You're not a range 2 offender. You understand that? In order to be a range 2 offender, you have to have 2 prior felony convictions. You don't have any felony convictions. You understand that?
Yes, sir.
You can agree to plead outside of your range as long as it's within the range of punishment for that crime, that E felony, as long as you're doing that in your best interest. You understand that? So you agree to plead outside of your range as a multiple range 2 offender. And that range 2 sentence will carry anywhere from 2 to 4 years in prison. And you've also agreed that at your sentencing hearing, you will be sentenced to consecutive sentences on these 3 counts. So it's a minimum sentence of 6 years in prison to as much as 12 years in prison. Do you understand that, sir? You understand normally, unless you make that agreement, you cannot be sentenced to more than 2 years in prison. If they were run consecutive, it would be a total sentence of 6. Do you understand that?
Yes, sir.
Mr. Johnson, once the court sentences you, you lose all of your rights to citizenship. You understand that, sir?
Yes, sir.
If you're sentenced on this case, in order to serve the sentence in prison, you'll be a convicted felon. That felony conviction will be on your record forever. You understand that, sir?
Yes, sir.
If you were sentenced to a federal penitentiary sentence, even placed on probation, would have to render you infamous. For the rest of your life, you lose all of your rights to citizenship. For instance, you lose the right to vote. You could not vote until you completed that sentence, and the right to vote was restored or given back to you by a judge in circuit court or by a certificate from the Tennessee Department of Corrections. Do you understand that, sir? As a convicted felon, Mr. Johnson, you could never serve on a trial jury. You can never possess. You can never carry. You can never buy. You can never own any handguns, firearms, rifles, shotguns, pistols, ammunition, or even bullets. Mr. Johnson, if you had in your possession, in your hands, in your pockets, on a house or car or any other place, if you possess any firearms, if you have one single bullet in your possession, United States Prosecution Federal Court, unlawfully possessing a firearm as a convicted felon, you can be sentenced to federal penitentiary for a long time. If you possess any handgun or firearm, Tennessee can prosecute you for that. That carries up to 30 years in state prison. Do you understand that, sir?
Yes, sir.
Again, you've been sworn to tell the truth, and everything that you say has to be true. You understand that, sir?
Yes, sir.
You have any questions about the rights that you waived, the guilty plea you entered, or this agreement you have with the state of Tennessee, Mr. Jermarcus Johnson?
No, sir.
Have any complaints about anything that Mr. Corman has done since he's been your lawyer, sir?
Yes, sir.
How long has Mr. Corman been your lawyer, Mr. Johnson?
About 8 months.
Did he get this 7 months? Did he get discovery for you?
Yes, sir.
Did he let you know what to say would try to prove if you had a trial?
Yes, sir.
Did you have anything that you wanted Mr. Corman to investigate for you?
No, sir.
Do you have any complaints at all about anything that Mr. Corman has done or has not done since he's been your lawyer?
No, sir.
Do you also understand, Mr. Johnson, that part of this agreement, this memorandum, adopted by the parties, will be filed as a public record with your guilty plea? You're pleading guilty to those 3 counts in that information. You're also agreeing that you be sentenced as a range 2 offender, even though you are, in fact, only a range 1 offender. You understand that? You also are agreeing that those 3 felony convictions will be served consecutively to each other or one another, making that an effective sentence of minimum of 6 years to as much as 12 years in prison. You've also agreed that the state of Tennessee has not made you any promises, no recommendations to your sentence other than they would detail to the court any cooperation and truthful testimony or statements that you have given that may have aided in the prosecution. As Mr. Hagerman just told you, if some of those other cases go to trial, Justin Johnson or Cornelia Smith or Hernandez Godan, if those cases go to trial, the state of Tennessee might actually call you as a witness. You understand that? You understand you waive your right to remain silent, and you could in fact be compelled to testify if those other cases are tried.
Yes, sir.
You'll also be supervised by Shelby County Pretrial Services. They reporting all parties recommending that you be released on bond in an amount of $25,000. And once you make that bond, Mr. Johnson, you have to report to Shelby County Pretrial Services. They're reporting. We'll file that order with this guilty plea also. You would have a curfew from 9 o'clock at night until 5 o'clock in the morning. You have to be at home every day, all day, until your case is disposed of, unless you are working. I want to encourage you to work, and if you are working, you have to provide to pretrial services proof that you are in fact working. Otherwise, from 9 o'clock at night until 5 o'clock in the morning, you have to be at home every day, every night. You understand that? You'll also be in order to enroll in any other programs that pretrial services deem either group programs or individual programs, such as random drug screens. You have to check in with these folks automatically, regular contact with the person who supervises bond, and you also cannot possess a firearm while this case is pending and while sentencing is pending. Do you understand that, sir? Do you have any questions about any of those conditions that we talked about? Mr. Jermarcus Johnson, I'm going to find for the record that Attorney Mr. Joshua Corman has represented you satisfactorily. I find that Mr. Corman and this court have explained all your rights to you. I find that you understand those rights and that you waived it. You've given up those rights intelligently and knowingly. I do find that there is a factual basis. There is a legally sufficient reason for this guilty plea, which has been entered freely and voluntarily. And upon you plead guilty to information I-23-00019, counts 1, 2, and 3, Class E felonies of accessory after the fact. Mr. Johnson, it is a judgment of this court that you are guilty. The court is going to delay the execution of these judgments. It will delay a sentence on this case until Ms. Corman, Ms. Mine, Mr. Hagerman, do you have a recommended date for the next setting on this case?
We get about 45, or somewhere between 45 about 60 days.
60 days is August 10th, Thursday, August 10th is the day for all lawyers.
That's a good day, Judge. Thank you.
Yes, sir. Mr. Johnson, we're going to delay the execution of these judgments. We're going to delay the sentencing on this case to a sentencing hearing on August 10th, 2023. Be back in this courtroom at 9 o'clock that morning, unless that date changes, and stay in touch with the Corman in case the date does change. But I'll see you back in court on August 10th, that's a Thursday at 9 o'clock that morning. Make sure you go to pretrial services on Tuesday morning. They will not be open on, they will be open on Monday. We won't be in court on Monday. Go to pretrial services on Monday morning, June the 12th at 9 o'clock. They're on the 8th floor in this building. One of the deputies will make a copy of the pretrial pretrial day reporting order for you. Take that with you. Go talk to those folks Monday morning at 9 o'clock. They will supervise this bond. Make sure you maintain contact with them. Make sure you answer those calls and those curfews. And make sure you commit to those random drug screens, because that will be required as a condition of this bond. Stay out of trouble. Don't get yourself arrested again. Be safe. And I'll see you back in court on Thursday morning, August the, I think I said August 9th, Thursday morning, August 10th. Thursday morning, August 10th at 9 o'clock. Any questions, sir?
No, sir.
Ms. Johnson, step down from the witness stand. See you in 2 months, sir. Thank you, sir. Mr. Hagerman and Ms. Munn.
Yes, sir.
The indicted case, 2204-769, do you want to dispose of that today or carry it?
I'm sure it'll be sent to that same date, huh?
Madam Clerk, show the other case 2204769 set for report on Thursday, August the 10th.
If the Ms. Clerk could make a note that the bond that your Honor set covers both cases.
The bond $25,000 covers August case, the information case, and the indicted case 2204769. I don't know if the bond was on that case, but show the bond, a collective global bond of $25,000 to cover both cases. Anything else we need to address on this case?
No, Your Honor, thank you.
Ms. Corbin, Ms. Mond, Mr. Hagerman, thank you all. Mr. Johnson, I see you on August 10th. Stay out of trouble, sir. Be safe. We'll get that copy of the order to you in a few minutes, okay? Thank you, sir. Yes, ma'am.
All right, for those of you who are just joining us this morning, that was a live look inside of Judge Coffey's courtroom, Division 7 in downtown Memphis today, as Jermarcus Johnson is pleading guilty to lesser charges in the shooting death of Young Dolph, a.k.a. Adolph Thornton Jr., who was shot and killed in November of 2021. Let's get to exactly what happened in court today. A few updates for you. The lesser counts that Johnson pleaded guilty to were 3 counts of being an accessory after the fact. The attorneys discussed that quite in detail. It was a little hard to hear in the courtroom because of the microphones there, but they described the use of a cell phone, a car, and even money. His attorneys actually argued that Johnson had no involvement in the shooting or the murder of Adolph Thornton Jr. They say that he was involved only after the fact, helping his half-brother, Justin Johnson, which is also one of the defendants in this case as well. Let's go through what we know so far when it comes to who Jermarcus Johnson is. This is actually his second court appearance this week. Again, pleading guilty to those lesser charges of being an accessory after the fact. Now, the indictments already told us that we knew Jermarcus Johnson allegedly helped his half-brother escape after the murder and even arranged payments to the other defendants. The DA's office announced days ago that this plea deal was on the table and Johnson took it. He is now facing what could be between 6 to 12 years in these counts per count. He is about 25, 26 years old. Johnson turned himself in for this crime in November of 2022, but he was also the 4th and final arrest that police made in this case. Let's take a look at the other defendants who are also facing charges. It's Justin Johnson, Johnson's half-brother, Hernandez Govan, and Cornelius Smith. Justin Johnson and Smith are both due in court today. We're going to keep you updated on those charges and what they're facing. Those charges include first-degree murder and criminal attempted first-degree murder. Govan is facing the same charges plus conspiracy to commit first-degree murder. But before we let you go, we do want to take a moment to remember why we're here. A young man was killed in the town that he grew up in South Memphis. That is Adolph Thornton Jr., a.k.a. Young Dolph. For many, he was a music star for the fans who loved him. But remember, Dolph was also a father and a family man. On November 17, 2021, Dolph was shot and killed at Makita's Cookies on Airways Boulevard. You may remember, he was back in home in Memphis for his annual turkey giveaway before Thanksgiving. Police say that they were able to make the arrest based on several surveillance footage videos that showed the gunman outside. As we continue to cover the latest update in this Young Dolph murder case, we are going to keep you updated with all of these developments. Let's go right now. The lawyers are accepting and taking questions. Let's try and listen in.
To help Justin evade authorities and continue his flight from this crime. So he had a role in the conspiracy, but it was entirely, everything was after the murder happened. So we took that into account, as well as his truthful statements to authorities, and you have the disposition that you have today.
Can you talk about how this just gives more confirmation that you all have the shooters in custody?
Like we told you the first day that we're here for this case, Justin Johnson, Cornelius Smith were the shooters, and that's what they're indicted for. That case will get a trial date, hopefully relatively soon. You heard in court that this defendant had identified Justin Johnson in pictures, and you heard what he testified to in court and what we told the court, and I think those things speak for themselves.
And just talk about Jermarcus Johnson to testify.
I couldn't hear you.
Do you expect Jermarcus Johnson to testify if there's a trial?
As we said in court, that's very high probability.
What day, because I got lost in the mix right there. What day did you say Jermarcus Johnson actually took possession of the car and the cell phone?
About a week after the crime.
So how long has kind of this deal been in the works, and, you know, was Jermarcus Johnson, you know, immediately helpful to your guys' investigation, or did that take a little bit of time?
Really can't comment on facts we didn't get to in court. I can say that he's been 100% helpful, and I can say that he turned over the cell phone, which is evidence in the case, and sort of leave it at that as far as time.
So one of the conditions of the plea deal is that he testify in the trial against his brother and against Mr. Smith. Is that right?
There's a good possibility that he testifies in a trial against his brother and Mr. Smith. He has to tell the truth. That's what this was guilty plea is hinged on. He has to tell the truth.
All right,
Do
so
we
you said
expect
that there was
anyone
the...
else to take a plea deal?
I couldn't comment on that even if I knew.
All right, so you said that there was the car, but the car was not the same one that was used in the murder. What car was
Correct.
that?
This is a different car that Mr. Johnson owned. Again, these are facts we didn't get into in court, other than it was a different car, and his taking possession of the car aided in his brother's escape from law enforcement.
As well as the cell
What
phone,
happens to that
correct?
conspiracy
Correct.
charge now?
It's reset along with along with the cases for which he pled guilty. It's still pending the same day.
Could you break down the three accessory after the fact? We know the car and the phone, that's one. What were the other two?
There's three. So there's the car, there's the phone, and there's the fact that he used the phone for two different purposes, and that was to deceive the probation officer into thinking that Justin Johnson was still in Memphis when in fact he took flight after the crime to other places, and then using the phone to coordinate communications with Cornelius Smith.
So Jermarcus Johnson's the first person charged to plead guilty or be convicted in this case. How does this help you moving forward with the other defendants in the case?
Well, I say litigation, especially on conspiracy cases where you have multiple players, multiple different people doing different things. In order to get those cases to trial and to get those successfully prosecuted, it's a little bit like chess. You got to set up your pieces before you start making moves. And it's setting up a piece.
And just for clarification, Jermarcus Johnson didn't receive any payment.
Jermarcus Johnson, no, absolutely not. His only involvement in the case is what we just outlined to you. About a week or so afterwards, he took acts that helped his brother evade law enforcement.
A while back, Judge Coffey indicated that most probably these cases move at a certain pace, right? Said maybe not next year, the year after. Does this in any way accelerate? Could we see the case like actually come to court sooner? Maybe next year, maybe?
Maybe. I mean, I don't know. It's going to depend on the other attorneys, and it's going to depend on just when they're ready and what dates we get.
What are Thornton's family's thoughts on this deal?
Mr. Blue has sort of been the family representative as far as coming to court. But we had a conference call with the family yesterday. They understand what this is about, and they're encouraged by the progress in the litigation, and ultimately one day they want to see a trial on this thing, and they know this is a step toward that.
Is there a chance that he could serve just only probation and no prison time?
I don't want to comment on what his sentences could be because we haven't gotten there yet. We have to have a sentencing hearing, and the judge will make determinations. He's pled guilty to 3 Class E felonies. The sentence is between 6 and 12 years. On E felonies, you're eligible to ask for diversion, probation, or whatever, but those are decisions for a different day by this judge.
So I just want to make sure that I'm getting this clearly. So each count of accessory after the fact, there's the reception of the property as one accessory after the fact, and then each usage of the phone is 2 different accessory charges?
So what's important is you got 3 accessory charges in total. What those things are about taking receipt of the car and the phone, and then using the phone in manners that help Justin Johnson evade law enforcement. He's pled guilty to all 3. He's agreed to be a range 2 offender, even though he's actually a range 1 offender. So he's agreed to a sentence between 2 and 4 years on each one, even though if he went to trial on those charges, he wouldn't get that much time. It would be between 1 and 2 years. He's also agreed that they're all consecutive to each other. So his total exposure is 6 to 12 years on the 3 charges, and sentencing is pending.
What did he agree to range 2 and not range 1?
It's a product of negotiations between the parties. It's not atypical.
One of the outstanding questions here is the motive for the actual killing. Can you discuss that at all at this point? Simply money or something else?
I can't comment on anything on the record. Can't remember whether or not our indictment gets into the motive or not. But I think there probably will be some information forthcoming about that sooner rather than later.
All right, I remember you said in there that he had said that he did see there was payment to Justin. Do we know where that payment is coming from, or who did he receive that from?
I can't comment on that. All right, everybody.
Thank you.
See everybody.
All right, we were just listening in to attorneys representing the state. I believe that was Paul Hagerman describing exactly what will happen next in the few weeks to come. Also, that Jermarcus Johnson could possibly testify against his own half-brother and another defendant in this case, Smith. Of course, we will continue to keep a close eye on this case and continue to follow any new developments that we will receive. To keep yourself up to date on all of the latest, you can go ahead and download the ABC 24 News app for Apple and Android users. You can also text the word app to 901-321-7520, and we will send that link straight to your phone to download. We will have more details and more information for you today. Join us at 11 for Midday.